Hello and welcome to Timmy Mac Law with me, Mr. McClellan. For this video, we're going to concentrate on the concept of damage. And right from the very get-go, let's be clear about the difference between damage and damages. So damage really is the negative consequence of what has happened to the claimant. So it could be a broken arm, it could be damage to their property, and it's them seeking redress for that particular outcome, the damage. Damages though, well that's really a bit more positive for the claimant if their claim succeeds. And often in the context of damages, we are referring to compensation, redress, which means money for the claimant, again, should their claim succeed. It's really common for students to get the two mixed up. They forget the importance of the letter S between damage and damages. Well, for this video, we're concentrating on damage, so just be clear on that right from the very start. And in order to explore the concept of damage, we're going to focus on causation and remoteness of damage. And this falls in the context of liability for physical injury and or damage to property under the tort of negligence. And remember, a person is negligent if they fail to do something which they really should have done, or they do something which they really ought not to have done. And in order to determine liability for physical injury and or damage to property under the tort of negligence, you must return to this magic 3-bullet point formula, and you've got to know this instinctively, and that's why I'm going to repeat it once again. I have covered videos on each of the first two, so please check out those before you carrying on listening to the rest of this particular video on causation and remoteness of damage. So, first bullet point, the defendant must owe the claimant a duty of care, and in order to determine a duty of care, you must concentrate on the neighbour principle and the Caparo 3-part test. The defendant must then breach their duty of care to the claimant, and in order to determine what standard of care must be expected, you've got to look at the concept of the reasonable man and risk factors. And then finally, and the relevance of this particular video, the breach by the defendant must cause damage to the claimant, and that's where we're going to bring in causation and remoteness of damage. And really, we're going to focus on this particular principle here. The loss should not be too remote from the act or inaction. And I've put in the word inaction there just to highlight the importance of omissions, which apply equally insofar as the relevance of causation and remoteness of damage. Omissions are important as well as actions in this particular topic. So the loss should not be too remote from the act or the inaction, and really you're looking for that close causal chain, that identifiable chain between the defendant's actions and the damage caused to the claimant. And if you can establish that, therefore you have satisfied factual and legal causation. Now there are some similarities in this topic of factual and legal causation in the criminal context, but there are some notable differences too. So be prepared to keep your criminal hat on, but then to take it off and refit your tort hat, and be very deliberate in your thinking when it comes to that, so you don't get the two mixed up. Now let's concentrate on factual causation, causation in fact, and this really is where it is very similar to the criminal context when it comes to factual causation, because we're going to rest on the but-for test. But for the breach of duty in the tort context, would the claimant have suffered the loss? And our go-to case for this is Barnet versus Chelsea and Kensington Hospital Board 1968. In that particular case, you had the claimant who was a patient who was suffering from severe stomach pains. They went to the hospital, but the hospital failed to give an examination to the patient, sending them home, where the claimant then died. Now, it was actually the claimant's widow who brought the case against Chelsea and Kensington Hospital Board, arguing that they had failed in their duty of care to her husband. And indeed they had, except that their failure to uphold their duty of care to the patient, well, it didn't actually cause his death, because the severe stomach pains were actually caused by arsenic poisoning, and there was nothing that the hospital could have done, even if they had examined him properly. So therefore, if we apply the principle of the but-for test, but for the actions or indeed the breach of duty, would the claimant have suffered the loss? Yes, they would have anyway. The patient would have died anyway because there was nothing the hospital had done. It was fairly obvious that the care given to the patient was poor. They had breached their duty, but it didn't cause the patient's death because he would have died anyway. But for test, therefore not satisfied, and therefore no liability on behalf of the defendant, in this case Chelsea and Kensington Hospital Board. So, but for test, very similar in the tort and criminal context, but now when we get to remoteness of damage, this really refers to causation in law or legal causation, and when it comes to the tort context, it's very different here. So chuck away your criminal law hat and put on your tort law hat, because we're going to focus on these three key principles. Test of reasonable foreseeability, then we're going to go to the kind or general type of damage, and then we're going to look at taking your victim or indeed claimant as you find them. So I'm just going to highlight these three key points that you will do well to remember. So I'm going to begin by actually looking at what the law originally was when it came to remoteness of damage. And it was based on the principle that the defendant was originally liable for all losses stemming from the case of Polemis 1921. So the defendant was liable for all losses which were a direct consequence of their action or indeed inaction. And in the case of Polemis, you had a group of dock workers who were loading and unloading wood from a ship. They dropped some wood to the hull of the ship, to the bottom of the ship, and it actually generated a spark, probably because it came into contact with some sort of metal, and it ignited a fire which destroyed the ship. And because that was the direct consequence of the defendant's actions, they were liable for the full extent of the damage, the destruction of the ship. Even though they couldn't predict that particular outcome, they couldn't have foreseen the fire which was eventually caused, and therefore they couldn't take any preventative action to make sure it didn't happen. But nevertheless, the principle, which really is our starting point for exploring remoteness of damage, the defendant was originally liable for all losses which they had caused. So it's a very wide and broad level of culpability attached to the defendant. They have to accept full responsibility for the consequences of their actions or inaction, even though they perhaps don't have a sufficient, I would argue, level of fault for that particular outcome. It's very blunt, it's very harsh, and because of that, well, the law really has injected a greater element of fault in order to determine the liability in relation to the extent of the damage caused by the defendant. So this is what the law has now become, and it's based on this test of reasonable foreseeability. So this is now your starting point. And the defendant is liable for damage only if it is reasonably foreseeable. And you can detect that element of fault which has been injected into the law, because the defendant is only liable if they can reasonably foresee the consequence of their actions. They can reasonably foresee the damage which they have caused. And this stems from the rather famous case which is nicknamed the Wagon Mound 1961. You are okay to refer to this case as the Wagon Mound. And the Wagon Mound itself was the name of a vessel which was harboured in Sydney Harbour down under in Australia. Now the Wagon Mound vessel actually suffered from an oil spill. So therefore oil has now leaked out from the vessel into the water of Sydney Harbour. And then worse was to come, because the oil then ignited as a result of some cotton material coming into contact with a spark which was generated by some manufacturing which was taking place on the wharf side. It ignited the cotton, which in turn ignited the oil, and then you had a rather large fire which damaged some neighbouring vessels and actually caused damage to the wharf side of Sydney Harbour. So it led to the question as to what damage were the defendants actually liable for? And it came back to this principle where they were only liable for damage which was reasonably foreseeable, and that was the environmental damage caused by the oil spill. Of course, if you are the responsible person or party for an oil spill, you're obviously going to cause environmental damage, but it couldn't reasonably foreseen that the oil would set on fire and therefore caused all the damage to the neighbouring vessels and the waterside of Sydney Harbour. So the defendants were not liable for that because they couldn't have reasonably have foreseen that damage. And then we get to the next principle, which is the thing that I really want you to hold on to, because I think this really does establish your level of comfortableness, as it were, security, as it were, with this particular topic. The kind or general type of damage must be reasonably foreseeable rather than the specific nature. This isn't overall an easy topic to understand or indeed apply, but I think if you hold on to this and you can be very clear about this, you'll be doing very well in order to actually grasp this particular topic. So the kind or general type of damage must be reasonably foreseeable rather than the specific nature. And the specific nature of the damage can be unusual, and this stems from the case of Bradford versus Robinson Rentals 1967, and this really is my go-to case. Whenever I feel a little bit unsure as to this particular topic, then I will return to this particular case, and it just clarifies matters in my mind to the extent that I can feel more secure with this topic. So let's just have a look at the circumstances of the case of Bradford versus Robinson Rentals 1967. And this particular case involved the claimant travelling 400 to 500 miles on an exceptionally cold January day in the UK. Now, we're used to cold January days in the UK, but consider that it was exceptionally cold on this particular January in 1967, let's say. And the claimant was spending a long time in their vehicle, and the vehicle itself didn't have any operational or working heating function. Now, the reason for their journey was to go to the aid of another vehicle, which clearly belonged to Robinson Rentals as well, the company that they worked for, but yet that particular vehicle didn't also have any operating or working heating. And therefore it's fairly clear that despite the reasonable precautions taken by the claimant, they wrapped up warm as best as they could do, they were going to feel very, very cold for an awfully long time. Now, I'm used to feeling cold in the UK, as many UK citizens no doubt are. You get the shivers, you can get a bit of a sniffle, you can shake, and it can be very, very uncomfortable. But the claimant in this particular case actually suffered from frostbite, which is very, very unusual in the UK. It normally doesn't get that cold in the UK. And arguably that couldn't have been foreseen because it's so unusual in the UK. But what could have been foreseen on the part of the defendant, on the part of Robinson Rentals, is that a cold injury would result. So could the kind or general type of damage be foreseen by the defendant? The answer is yes. A cold injury could have been foreseen. Yes, the specific nature of that injury is unusual. In this particular case, it was frostbite. Nevertheless, that falls under or into the scope of the general type of or indeed kind of damage. Think of your cold type injuries or damage that you can suffer from. Shivers, a runny nose, you can catch a cold if you like, all comes under the umbrella of a cold type injury, and in there as well you can get frostbite too. So it falls under the remit, the scope of the kind or general type of damage which was foreseeable. And on that principle, the claim succeeded and the defendants were liable. So hold on to that particular principle, and I think it will serve you well. It does not matter if the damage occurred in an unforeseeable way. So long as the damage is reasonably foreseeable, it doesn't matter if there was a weird or strange sequence of events which caused it. So, case examples here, Hughes versus Lord Advocate, 1962, and in this particular case, you had two boys who were exploring, if you like, a manhole which had been dug up by workmen, and the workmen had left paraffin lamps which the boys then took, and they went down into the manhole, and it caused an explosion when one of the paraffin lamps was dropped. Now, the explosion was unusual and it was unforeseen. Nevertheless, the damage wasn't. The damage being burns to the claimant, and therefore on that basis, because the damage was reasonably foreseeable, the claim succeeded. Yes, the explosion which caused the damage wasn't reasonably foreseeable, but the damage was. You leave paraffin lamps unattended, it's going to be an allurement for children, and therefore they may well suffer burns. However those burns happen to them, well, it kind of doesn't matter. The damage which was caused, the burns, was reasonably foreseeable, and therefore we have liability on behalf of the defendant. Equally, we've got the more modern case of Jolly versus Sutton, London Borough Council, 2000. And this case, you may revisit it again, or certainly come across it again, when you come to looking at occupier's liability. So when it comes to occupier's liability, sorry, I'm just getting rid of my low battery logo on my mobile. But yes, you will see this case when it comes to occupier's liability. Nevertheless, in this particular context, you had the claimants who were the relations of two young boys, about 14 years old, who were actually carrying out repairs on a disused boat. So they'd stumbled across a disused boat, which of course is an allurement for children, but they weren't messing around with the boat, they decided to repair it. And unfortunately, the jack which was being used by the boys to prop up the boat actually went through some rotten wood on the hull of the boat, and the boat of course then collapsed and caused severe spinal injuries to one of the children. So very serious outcome for the case. Now, the outcome was of course foreseeable, damage being caused to the children. But the way in which it was caused, was that foreseeable? Could you really have predicted that two boys would have gone on to repair a boat that was just left? Children tend to play around with things. They don't tend to repair things that are just left. But nevertheless, even though it was a strange sequence of events which led to the damage, the spinal injuries, that was reasonably foreseeable. Yes, it wasn't necessarily reasonably foreseeable that the boys would repair the boat, but nevertheless, it was held by the court that it was reasonably foreseeable that children would meddle with the boat, and I think repairing comes under the remit of meddling with a boat, and therefore the extent of the injuries or the kind and specific type of the injuries were foreseeable, and on that basis, the defendant was liable. Now, final principle, in relation to the kind or general type of damage must be reasonably foreseeable rather than the specific nature. There is no liability for unknowable consequences, coming from the case of Doughty versus Turner Manufacturing Company Limited, 1964. And in this particular case, you had an asbestos lid, the building material asbestos, which fell into some molten liquid, and after a few moments it caused an explosion which caused severe burns to the claimant. Now, it wasn't known that an asbestos lid coming into contact with molten liquid would actually lead to an explosion. Because, if you like, that had never happened before, therefore it was unknowable that it would lead to that particular consequence, and therefore you couldn't take preventative steps to avoid it. And in the absence of that particular level of fault, or that example of fault, there was no liability, therefore, for the defendants. So, if there is unknowable consequences which have been caused, there is no liability for those unknowable consequences. And then finally, we have to take the victim. I don't always like using the word victim in the tort context. I prefer to use the word claimant, but nevertheless, take your claimant as you find them. And this really does have echoes of the criminal law, so revisit your criminal hat, if you like, and quickly put it back on, because it's the same principle under tort law. It is the eggshell skull, or indeed you'll be more familiar with the thin skull rule. The defendant's liability is not lessened because the claimant had a pre-existing condition that made the injuries worse. So let's have a look at a couple of cases in the tort context, Smith versus Leachbrain, 1962. In that particular case, you had molten metal which came into contact with the lip of the claimant. Now, the claimant actually suffered from a pre-existing cancerous condition, and as a result of the burn from the molten metal coming into contact with the lip, it actually led to the claimant developing cancer. And therefore the claim was on that particular basis. Now, of course, the defendant argued, well, we can't be blamed for your pre-existing cancerous condition, which probably made you more susceptible to cancer developing to a greater extent. But nevertheless, you have to take the claimant as you find them. It's not the fault of the claimant that they have necessarily a pre-existing cancerous condition, and therefore the defendant was liable for the full extent of the claim, the cancer that had been caused as a result of the defendant's actions. Equally, a more modern case, just to finish up on, Gabrielle versus Kirklees Metropolitan Council 2004, and this was where children had been playing on a building site, and one of the children had actually suffered from eye damage to their sight as a result of mud or indeed a hard object being thrown into their eye by another child. Now, the council argued that they couldn't have necessarily have taken responsibility for the pre-existing condition of the children. Pre-existing condition insofar as they were children. Well, that particular argument didn't hold much weight in court because I don't feel very comfortable with the pre-existing condition of childhood, but nevertheless you have to take the claimant as you find them. Children are more vulnerable, they engage in behaviour which is different from that of an adult, and you have to therefore expect that and take reasonable precautions against that. The council did not necessarily prevent children from coming onto the building site. They could reasonably foresee that children would play in the building site, and it could reasonably be foreseen that they would throw things at each other, and therefore the council, the defendant in this particular case, were liable for the injuries caused to the children. So anyone who's more vulnerable, then the defendant has to take that particular claimant as they find them. Hope all of that content was useful as ever, and thank you very much for watching and listening.